Many federal prisoners hear about something called a 2241 petition. Some believe it offers a second chance after a 2255 motion has been denied. Others hear that it can be used to challenge a conviction, reduce a sentence, or reopen issues that were already decided years ago. But after a major Supreme Court decision, relying on outdated information about 2241 petitions can become extremely dangerous. Because what many people think they know about this process may no longer reflect today's legal landscape. In this video, we're going to break down 5 critical things prisoners and families should understand about federal 2241 petitions after the Supreme Court's decision in Jones versus Hendrix. And make sure you stay until the end, because one of the biggest mistakes families make today is relying on legal information that was accurate years ago, but may no longer apply. Let's start with the first thing you need to know. What exactly is a 2241 petition? A 2241 petition is a type of federal habeas corpus proceeding. Historically, it has been used to challenge certain aspects of custody and imprisonment. Unlike a 2255 motion, which is generally filed in the court that imposed the sentence, a 2241 petition is usually filed in the federal district where the prisoner is currently confined. That distinction is important because many people mistakenly believe these two legal procedures serve the same purpose. They do not. Which brings us to the second thing families should understand. 2241 and 2255 are not interchangeable. A 2255 motion is generally used to challenge the legality of a federal conviction or sentence. A 2241 petition has traditionally been associated with issues involving how a sentence is being carried out. For example, matters involving sentence calculations, custody-related issues, prison disciplinary proceedings, or other questions involving the execution of a sentence. And understanding that difference is critical, because federal courts carefully examine whether a claim has been brought through the proper legal vehicle. Now let's talk about the development that changed everything. Jones versus Hendrix. For many years, some federal prisoners attempted to use 2241 petitions when they believed a 2255 motion was unavailable or could not provide relief. Different federal courts developed different approaches to those arguments. Eventually, the issue reached the United States Supreme Court. In Jones versus Hendrix, the Supreme Court significantly limited the circumstances under which many prisoners can use 2241 petitions to challenge the legality of a conviction or sentence. And that means a lot of information still circulating in prison law libraries, online discussions, and inmate-to-inmate advice may no longer reflect current federal law. This is where many families unknowingly make a serious mistake. They hear about a case from years ago, they read an old legal guide, or they rely on information passed around inside an institution, and they assume the rules have not changed. But federal post-conviction law evolves, and major court decisions can dramatically affect available legal pathways. That is why current information matters. Now here's the fourth thing families should understand. 2241 petitions still exist. Jones versus Hendrix did not eliminate 2241 petitions. Federal prisoners continue to file them. However, the types of issues commonly raised may be very different from what many people expect. For example, some petitions involve sentence computations, questions involving custody credits, good conduct time calculations, certain prison disciplinary proceedings, or other issues involving how a sentence is being administered. The specific facts of a case often matter tremendously. And that leads directly into the fifth thing families need to understand. Federal post-conviction law is extremely technical. Many people assume that if something feels unfair, there must automatically be a legal remedy available. Unfortunately, federal courts apply detailed procedural rules, jurisdictional requirements, filing restrictions, and legal standards. And many petitions are dismissed before a court ever reaches the underlying arguments. That is why education matters, because understanding the process can help families avoid common mistakes, unrealistic expectations, and unnecessary frustration. Now let's return to the warning we mentioned at the beginning of this video. One of the most dangerous mistakes people make today is relying on outdated information. Federal relief law changes, Supreme Court decisions matter, and legal pathways that existed years ago may look very different today. That does not mean relief is impossible, and it certainly does not mean every case is the same. But it does mean that understanding the current legal landscape is incredibly important. Federal post-conviction litigation is often complex, emotionally exhausting, and deeply confusing for prisoners and families trying to find answers. But learning the basics can help people better understand the questions that need to be asked moving forward. If you'd like to learn more about federal relief developments, sentencing issues, post-conviction litigation, and educational federal relief resources, visit apexfederalrelief.com. That's apexfederalrelief.com. And if you found this video helpful, subscribe for future federal relief education explained in plain English. Because the more families understand the federal system, the better prepared they are to make informed decisions moving forward.